Broadcast is now starting. All attendees are in listen-only mode.
Olá, muito bom dia a todos os presentes. Nós vamos dar início então ao nosso webinar com a Karen Öqvist. É um prazer estar aqui convosco e mais uma vez é um prazer estar aqui com a Karen. A Karen não me está a compreender, ela não fala português fluentemente, mas por isso é que a sessão vai ser toda ela conduzida em inglês. Por isso eu vou-vos pedir apenas, vai haver uma apresentação da Karen e durante essa apresentação vão deixando questões, no final vai haver uma sessão de perguntas e respostas, portanto podem colocar as perguntas em português, não há qualquer problema, eu traduzo hoje para a Karen e depois traduzo de volta para vocês perceberem o que ela acabou de dizer. Well, Karen, I was introducing you. I was telling people to showering us with questions. So in the end, I can ask you all the questions and you can answer them as a specialist. So it's up to you now. Please just go ahead. We are
Yeah. Hi there, everyone. I didn't understand everything that was just said, or maybe nothing that was just said, but I've been working with GDPR since some years now, even before it came into effect in 2018, and I co-wrote the book for Hands-on Guide to GDPR Compliance. I'm also a DPO of several large organizations. My work has been in many different verticals. Some of them have been in insurance. Most recently, I've been working a lot in surveillance. So, and that is super, super cool when it comes to privacy. So now what I'm going to do is I'm just going to cover some of what I see as the grounding fundamentals of privacy compliance, and then we will move forward and look at a couple of examples of fines that have been out recently, at least in the last couple of months. And we can discuss what that means in practice. So, yeah, getting it right with GDPR compliance. I am not a privacy expert. I am a practitioner. I nobody's an expert, because GDPR compliance, to get this privacy nirvana in the EU, in an organization which is data protection by design, by default, you need to know not only enough about GDPR to be able to do your job, but you need to know who to get help from. It is a change management project. It's not purely about legal stuff. So we're going to be looking at three, well, I basically pulled out three little bits of the CPP training to have a look at, so you can get an idea of the scope of the training. A lot of it is, you've got the theory part, which is 1.5 days, and then you have a lot of hands-on. And we are going to be looking at GDPR from a context to see exactly where it came from. So we're going to be looking first at privacy dilemmas, a common language, and privacy risk. And then we will look at three examples, which I realize I forgot to put on this slide, but it comes later. So why are privacy dilemmas important? Because if you don't get it, that there is a dilemma, if you don't understand why people are making the decisions they're making, then you are likely to end up in a conflict situation. So basically, if we take the most fundamental privacy dilemma, transparency versus privacy. Basically, we all want to have privacy for ourselves, but not for anyone else. So now when we think about it, privacy is a fundamental human right. So it is actually basic to our very being. But at the same time, even though we want to protect ourselves, We want everyone else to be transparent with us. And this was actually brought up by a smart guy called David Brin in a very, very good book from 1998, quite some time ago, The Transparent Society, if you want a bit of bedtime reading. Now, if we move on to another privacy dilemma, and this is freedom of speech versus privacy. And this is creating a heap loads of problems, especially in Sweden, which is where I'm actually based. And the reason why is because freedom of speech laws is so strong that it has made the privacy law less weak. So what this means, for example, in Sweden, is that my personal data, and personal data is any data that is linked directly or indirectly to a natural person, that's a living person, from the moment I am born until the moment I die. So basically what it means is that my personal data is public data. And so it means as soon as my data becomes, it's like if my personal data is public, then I lose some rights. So for example, if somebody sits on TV and if they're some kind of celebrity, maybe they're a rock star or whatever, or somebody from the TV who's famous, as soon as they state, yes, I have been on drugs and I am coming out now of rehabilitation clinic, as soon as this goes out to the public, they lose their rights to that data. It becomes public. And this is a real problem because it means that in Sweden, I did not choose to have my personal data to be made public, but it is public. So this creates a conflict, a dilemma, a privacy dilemma. Then, of course, we've got societal function versus privacy. Now, in order for us to just get through our day-to-day lives, you know, we get up in the morning, we get in our car, we take our kids to school, we go to the doctors, we need to work. Everything that we do means that we need to share personal data. The personal data of our children needs to be shared with the schools. Our health data needs to be shared with the doctor. And there's data that needs to be shared with because we have to have a driving license and because we pay taxes for our cars, etc. And then, of course, there is personal data versus privacy. And this is a little bit more of a personal thing for each one of us. And we all go through phases in our life where personal safety becomes more or less important. But what is apparent is that once we get small children and we have children growing up in our environment, personal data becomes so important that we are very much prepared to forfeit our privacy in order to protect ourselves and our children. National security versus privacy. So we all are exposed to attacks from organizations that are more radical, and this could be in the form of bombs in the underground, or what we have in Sweden not so long ago, there was somebody that drove some kind of truck through the streets that killed some people. So basically, every time this happens, often there will be some effort to increase security, you know, at the airlines. Before we get on the flights, we are checked. And we need to have this in order in the name of the public interest. However, this is a dilemma because there needs to be a balance on how far you go. And of course, this was highlighted very much when the Snowden disclosures happened. And of course, it became more public understanding that basically the US government were collecting all data. Convenience favorite coffee shop. You go into a shop and you're using a store card, and all of this gives some very tangible benefits in your day-to-day life that improves the quality, but still it's a privacy dilemma. Now, one of the biggest challenges that I saw when I came, the first time I read the GDPR, that was in 2014 actually. It came out, the draft, in 2012. And The final version came out in the end of 2016, and what I noticed is that it was actually a very beautifully drafted piece of legal work that had been created, and it was based upon this human right in privacy, and it was nice legal text. But the problem is that people that are not legal would have problems being able to understand it. It needed to be, there were 6 words in there that I've already mentioned once: data protection by design, by default. It's actually written in the text in the GDPR that basically expanded, stretched legal compliance out of the legal function, which is like privacy notices and contracts and stuff like that, into every single business function. And so I was thinking, how are we going to make this piece of beautiful text, law, GDPR, the General Data Protection Regulation, in a format so that people who do not have a legal education can understand it? And I do not have a legal education. I've had some legal education when I've been working in security and privacy, when I've actually got my qualifications, but I'm not a lawyer and I don't speak the legal language, and most of us don't. So what I saw is that we needed to have a sort of a language that both the legal guys can speak and also the non-legal guys, so that we come together and we have a common language. And it means that we get to this legal text to make it operationalized across every aspect of an organization. And these are people that is running in purchasing, they're in IT, and they are in HR, that don't have the time or the effort to be able to understand what this complex legal language means in practice. So what I did is that I noticed that there is a common denominator which is used. They are the OECD 8 principles that are used globally by every country that has privacy laws as the lowest common denominator, and that is the Organization of Economic Development that came up with these principles. They were originally derived from FIPS, Fair Information Privacy Practices in the US. So even the US guys are thinking in this way, although it was evolved into international principles in 1980. So FIPS were derived in 73 and OECD privacy principles in 1980. So this was a long time, even before the first Data Protection Act came out, and even before UK, for example, had an act in, it was 81, I think they had the strong one, which was in the EU. Now let's go on. I find it quite difficult presenting. I can't see slides, so I can't see anybody out there. But anyway, these 8 principles, they start with collection limitation, and they are quite logical in that basically what collection limitation states: you should only collect personal data that is absolutely necessary for the purpose, and if appropriate, get consent. Now, consent is only one of 6 legal bases, but the legal basis, which comes from Article 6, is not covered in this presentation today. But we will talk a little bit more about this collection limitation when we look at an example on the last slide. Data quality. Now, this is not the same as the security guys or the IT guys may talk about data integrity. It's different. We, as natural people, from the moment of birth until we die, our personal data changes. And so data quality is about the fact our personal data quality needs to be upheld. It needs to be kept up to date. So if we had debts 5-10 years ago, which is showing us as red, this needs to be updated for today to show that you have no debts, so that it's not used in a way that's detrimental to where you are today. Data quality is also linking into another principle later, which is about the rights of the individual and their rights to question data quality. Purpose specification. There must be a specific purpose for the collection and the processing of personal data. If there is no purpose, then you should not be doing it. Use limitation. Now, the use of personal data is not the same as the purpose. So basically you have a purpose. Let's take an example. You are, let's say you are recruiting people. It's HR function. Now, how you use this data is maybe more than tied to the specific purpose. So you will actually need to store it somewhere, the data. You may actually go on and do something else with the data, but the use is multifold. And we could take another example. The purpose, you buy a book on, let's say you buy a book on Amazon.com. So you fill in a form on the website with your name and your address that basically is the purpose is that you want to buy the book. And your name and address needs to be provided in order that this book can be delivered to your home address. Now, how data is used internally needs to be strictly tied into the purpose. So your name and address needs to be shared with a delivery function internally so that they can actually deliver your book. And it may be they use an external provider. Let's take this. And then they need to share your name and address, and of course the book, the name of the book and the book, so that it can be delivered to your home address. Now, if marketing come in and sort of say, "Oi, another customer, yummy, yummy, you know, let's take that data," that is not aligned to the original purpose. It is separate. And in this case, if marketing wants to be able to use that data, the data subject needs to be informed that that is basically what is happening, or a separate purpose needs to be created for this. The way that I work is I like to keep everything very simple. You have a purpose. I sort of talk about a spider, a GDPR spider. You have a purpose, and then on the outside of this, you have all of the uses outside of the purpose. Now, what I'm looking for is that every single use needs to be strictly correlated with the purpose. If there is no correlation, then it is a mismatch. And it's not compliant. Security safeguards. Now, this is in Article 32 of the GDPR, and it's to do with the fact that you need to make sure that it's the normal security factors. You've got confidentiality of data needs to be protected, the integrity needs to be ensured, and the data needs to be available. The GDPR also talks about resilience. So you have the back-end systems need to be resilient to floods, to outages, and that kind of thing. But then there needs to be, for the user of the IT applications, there needs to be the availability that's always there online. Individual participation. Now, this correlates directly with the user rights within, the user rights within the GDPR, and these are articles 15 to 21. And it's not only those articles; the rights of the data subject are woven intimately through every part of the GDPR. So basically, the user has the right to be forgotten. They have a right to have access to their data. They have a right to know what's being collected and what's being done with that data. So they have the right to challenge the data quality, etc. They have a right to withdraw their consent if that is the legal basis used for processing. Openness. Now, there must be complete transparency when it pertains to what you are doing with personal data, which you are collecting and which you are processing. Now, openness, that has different facets in the GDPR. First of all, you have the privacy notice. The privacy notice that needs to be presented on or before collection of personal data, so that the data subject is aware of what you are doing with their data. And then you have aspects such as the breach notification. And then the openness is where on Articles 33 and 34, where you need to, one, if you have a breach, you have to, within 72 hours, notify the supervisory authority. And two, in Article 34, notify the data subject if it's looking that it will present a high risk of harm to the rights and freedoms. And we will come back to that bit in a moment. What is harm to rights and freedoms? What is privacy risk? Accountability. Now, if you have not followed specifically all of the other 7 principles and have evidence that you have done this, then it's not worth anything. So accountability is basically 2 factors. One is you need to have evidence that you are doing what you should be doing. 2 is that you need to have accountability and individual, and this is where the you have the controller, the processor. You need to have a DPO within the organization in certain instances, not in all of them. You know, for example, an organization that is collecting large amounts, large quantities of personal data will need to have a DPO. Yeah, so let's move on. So privacy risk. Now, is potential harm to the rights and freedoms of the natural person. So it's not just about the potential risk to an individual. It's not about, you know, where you are physically harmed. It is the rights and freedoms. So how does this translate to real life? Think now, if there is a young person and let's say there has been real examples of where a young girl has basically killed herself because a photo of her naked or doing something inappropriate is posted online, maybe by some so-called friends or an ex-boyfriend, and she will kill herself. So there has been no actual harm to her, but it has actually created harm to her rights and freedoms. And this must be really, really understood, because this is basically what the GDPR is about. It's about protecting an individual. Now, so if we come to the potential harm to rights and freedoms of the natural person, and if we think about the role of the DPO, so, and we also, if we sort of stretch back to the first topic I mentioned, which was privacy dilemmas. So basically, there is a breach in the organization, and the organization, they will be saying, no, we don't want to report this, because, you know, it's like if you take in Sweden, all breaches that are reported to the supervisory authority become by nature public data, and they're thinking, this is not good, we don't want anyone to know about this. Now, the role of the DPO is to stand in the shoes of the data subject. They are like, you know, if you talk about a consumer advocate, but they are sitting in the shoes. They are the data subject advocate. So what this means, if we're looking at the dilemmas, it means that you have a conflict, a potential conflict situation between the DPO and between certain individuals in the organization who are focused on the organizational risk, whereas the DPO is focused on the data subject risks. So this is something that basically the training does talk quite a lot about, in able to not only understand everything in the regulation on how it impacts an organization, how to operationalize and how to ask for the right help from the right people, but it's also how to deal with this potential dilemma that is happening every day, at least in my life as a DPO. Now, let's look at also at what is privacy risk appetite. So basically, when we're looking at what is privacy risks, let's take, I've only taken privacy risks, operational risks, and corporate risks here, but there's a whole load of them. But every privacy risk that happens will also be an operational risk. It will also be a corporate risk. So, but the difference with the operational risk and corporate risk is that that is looking more from the organizational perspective. The privacy risk is for the data subject. And the way that I normally advise is that the privacy risk should provide a feed to the enterprise risk management platform, whatever you're using, because they will feed into the other risks of the organization. They don't need to duplicate it. They just feed into it. And when we're looking at what is we have a risk appetite, it's like insecurity. The risk appetite is that, let's say that there's a risk that that the computers in your organization will get infected with a virus. So what do? Yes, you pay out to have virus scanning software on the computers. You will put scanning on the email server so that it actually picks up anything that's looking suspect. but then a decision is made to say, look, how far do we go on spending money to protect risk? And so the organization will say at this level, so there is now this much risk, and we need to spend this much money in order to mitigate those risks, but it's too much. So a decision is made to accept risk within the organization. Now, the same applies with privacy risk appetite, except that the DPO needs to stand in the shoes of the data subject, and he can't go out and ask, he or she can't go out and ask all the data subjects what is their risk appetite. He or she needs to take that in the stance of the data subject. What is the privacy risk, and can we accept it, yes or no? Now, I just thought I would take a look at, without half an hour, at three fines and sanctions. I just see that the third point there is wrong. It should say UK. Okay. So we had a really interesting fine, our first fine by the supervisory authority in Sweden very recently, last month. And it was a school, I won't try and say this for this because nobody else can understand it, it's Skellefteå, that was using facial recognition technology as a trial. So in the school, in this commune, they had children that were, when they came into the classes, they were using facial recognition to see when they came in and when they left, etc. And what was decided is that there was an insufficient legal basis for data processing, which led to this fine. And the reason why was, well, firstly, they were using biometrics, but secondly, you know, you can't. The insufficient legal basis is that, you know, they didn't get consent, and even so, it should be parental consent. And even so, you know, there is an imbalance in relationship, which means that consent is not legal. There has to be a balance in the relationship between the data subject and the actual controller in order for consent to be a legal basis. And it's not a legal basis here. So this is basically why they were fined. The problem is that there was another school just not long after that made a decision not to use RFID. It was a kindergarten, and they were thinking about using RFID, where the little kids, you know, they would have a little wristband on, and it was just a chip which basically, if they went out the perimeters of the school garden, it would actually put an alarm so the personnel would be able to go and get the child back. There was no linkage to a child. They just had any band on. It was just to protect the parameters, to protect the children. Now, they made a decision not to use this based upon this decision, which basically indicates that they didn't understand that, in fact, it was a really good use of technology, because the RFID chips, they were not linked directly to a child. It was used to provide extra protections for the children. And basically, there was no sensitive data. And if they had done their work properly, they could have actually done a DPIA, a data protection impact assessment, to show as evidence that they have been due diligence in how they had done this. So it's not that it would have been okay to go ahead, but it would have been smart to actually not just make a decision because this decision had been made, because they are completely different. Now, yeah, I'm sure this actually got a lot of publicity, and this is that Google was fined for violating children's privacy on YouTube. So they basically knowingly and illegally harvested personal data from children and used it to target ads. So this highlighted, I know I've chosen the child one again, but still what we have here is that, you know, children are, they are vulnerable people in the GDPR. So anything pertaining to children, one needs to be extra careful, but they most certainly cannot be doing what they were doing here. And to do it it's not just that they were doing it, doing something that's illegal, but they were being they weren't being transparent in how they were doing this. Yeah, and the UK one. Now, this is interesting because what they were doing is that it was actually on the headline, it was more to do with that they were doing calling, they were ringing homes and they were actually bothering them, nuisance calls as they call it in UK. But what I saw is the biggest thing here is that they were buying in leads, and they were not, so they were buying data, third-party data, and they were not checking that consent had been obtained from that third-party data. And so this is basically why they got this fine. And this is really important because it's like when we're looking at buying in third-party data for our marketing, you can buy it in, but in Sweden also the fact that public data is available, it means it's like, okay, do we need to have consent or not if it's public data? So there is some work that needs to be done, and I do recommend a data protection impact assessment to be done on all data that you are using, which is third-party data, just to make sure that you're doing it right. So, okay. Yeah, so that's it. You know, we've done this in 35 minutes, so we have time for questions now.
We do, Karen. Thanks a lot, and thanks a lot for your passion about the issue. That's usual. I'm used to it. Most of the people they aren't. So thanks very much. Well, in fact, I'm gonna ask the attendees to power out their questions now. In fact, we have one question, and
Only one?
yeah, for now. So you were really transparent about your presentation. So there's this person who's asking who evaluates the limitation of data recollection. So here in Portugal, and this is a known case, certain newspapers are obligating people to give their data in order to have access to the content inside the website.
Oh.
So who's the one? I think this is the question, and please correct me if I'm wrong. I'm talking to the attendee. Who can evaluate these and the legal?
Yeah. Okay, so what you're saying is that, because it sort of brought to mind something else, and I don't want to forget this. I want to talk about there's something else to do with consent, opt-in, opt-out type thing, and I want to go into the cookie thing after this. But what he's talking about here is to do with, you go on a website and they say, yeah, you know, you can have this nice report, but you have to provide your name and your address, your email, your shoe size, and everything else before they give you the report. Is that what they mean?
No, not necessarily. It's like a universal platform that has like 8 newspapers. I don't know the correct number, but
Okay.
it's just like a regular website where you have lots of news, and at some point, like after 20 seconds or something, it pops up something, and you need necessarily to log in to a platform that it's universal. It's something that they all signed in, and you need to have a login in that particular platform. Are you listening to me?
Yeah, I lost you for the moment.
Yeah.
Yeah. So basically, it's a newspaper. It's newspapers there. They have articles and things that you can read, but you need to have an account there. Yeah, and you can put comments and things. Is that what you're saying?
No. It's something that we've never seen before. It's like you have a platform that it's common to all of them, where you need to log in yourself and register and give your data, of course, so you can access their regular website. It's something new. It's a new approach, and I think the question is, in fact, if that's legal, and if it's legal or not. Who's the one that evaluates that kind of things? If you want to
Okay.
read a newspaper on the internet, one of these, you are obligated to give data like your age, your job function, and so necessarily.
Right. No, it's not necessary for the purpose. You know, if we go back to these 8 principles, and I said specific, there must be a specific purpose. You know, what's the point? There is no point. Why do they need your age? Unless, of course, they're doing some marketing and they're segmenting, they want to improve the service. But if they do this, then they need to be absolutely clear. And if we come to this, like, we go to the cookie, you know, the e-privacy regulation that is out now, and that is basically where it talks about the cookie banner that needs to be there. And I think this is a good example that links into this. The new cookie banner basically is that if your website is using, if you need to have a cookie on your website in order for it to function, you do not need a cookie banner. You need it to function, you know, to go into the website to use it, you do not need to have a cookie banner. But if you are collecting additional information that is unnecessary, then you need to have a cookie banner to say, look, we are collecting that you have surfed this site, and they will make decisions based upon this, but basically they have to ask your permission for any data that is not necessary for the functioning of the website. So this is similar in the way that there has to be a specific purpose, and if there is not a specific purpose, then this is illegal unless you have consented to this. But they should not stop you having access because you do not provide information that is not necessary for the purpose.
Okay.
You know, all that's needed. Yeah, if you want to read a newspaper online, what is needed? Maybe you have to pay for this. Maybe you need to, if you need to pay, then you provide your name and whatever. But you need to provide. You don't need to provide how old you are or and other stuff. Yeah, this is optional.
But the question, in fact, I think that's the basis of the question is who evaluates that need? Who's the one? Are we talking about the data protection impact, the DPIA you were talking about? That's what it's needed.
Yeah. So basically, what I do is that I'm actually doing loads of DPIAs because I'm actually sitting as DPO of innovation of a large organization. So it's all the new product technologies and things like that, which often is to do with collection of personal data in a very innovative way. So I would recommend, you know, doing a DPIA on any collection of personal data that is new, or that has changed in any way whatsoever. And in that, I would basically come out with some risks that I would want to be assessed. And sometimes I would, you know, some of the risks I would say, I need to talk to a legal guy. I need his help because I don't know, you know, I've done this before, but, you know, it's like, for example, if you look at the GDPR, it's got in the first, in Article 5, it talks about the processing of personal data needs to be fair and lawful. Now, you know, I am not a legal guy, so when I read those two words, I see fair, and I think, yeah, okay, that's fair, and lawful, yeah. But to a legal guy, when he reads those two words, his brain spans to the whole, you know, 200 plus pages of the GDPR, because those two words by themselves, and this is why I use these 8 principles, because those two words to a legal guy is something completely profound, it's everything, compared to what it would be for somebody that's not legal. So whenever I get to something, I get to a risk and I think, this is a legal risk, this is a technology risk, this is this risk, this is that risk, and then I put them in these categories. Then I go and see a legal guy, I go and see this guy, and I go this guy, and then a decision is made. And I do not make this decision by myself. I speak to my sponsor and we sit down together, and maybe it needs to be escalated because it has more effects that we need to get buy-in from higher up, especially when it comes to marketing.
I think it's perfectly clear now, and in fact the gentleman is thanking you for your explanation. So there's another question here. That's something that someone's asking you. That the person in question works with a lot of the organization that she works in works with a lot of transportation to their own clients. So the question is, they have the consent to use the data from the clients. Do they need the consent from the suppliers? Do you understand the question? You have the consent of the clients to use the data. But do they need consent from everyone involved in the process? I think that's it. Okay, if you are, please, Karen.
Yeah, well, basically the data subject must give. There needs to be. It's a legal basis. It's like with the suppliers. In this example, they will have a contract with the suppliers. So the legal basis for processing of personal data will be contract. And with the suppliers, it's different kind of personal data. But with the end customer, they are using the transportation services. So the fact is, it depends whether there is a contract between the customer and the provider of the transportation. So, for example, if I'm going to go onto a bus or I'm going to take a taxi, if I'm going to be taking a taxi, I have an app. As soon as I go into I download the app and I start using it, I have an intention to enter a contract. So that means I can use Article 6b, which is contract, as the legal basis. Consent is not needed unless you start going beyond what is required in the specific purpose for the contract, and that is to get me transportation from A to B.
Okay.
For example, take my name and use it for something else.
Yeah. Okay. So it's all right. You can use the data to the specific purpose. You are contracted.
Yeah.
Okay.
Yeah, but normally it wouldn't be. Normally, if it's transportation, it would normally be contract, because normally the customer will pay for it and then they enter into a contract.
Okay, it makes sense.
To
end up this question, it is enough to have it in paper, or it's also needed in an informatic, in a technological platform? It's a question. The question is about that.
Basically, the material scope of the GDPR is both digital and paper format.
Okay.
You don't need to, but what you need to have is the evidence, and you need to store this in a safe place. If it's a paper, you need to put it in a cupboard and lock it up and make sure you decide who has access and who doesn't.
Okay.
You don't leave the key in the box.
Okay.
I work an awful lot also with franchise business and small businesses. So I see a lot of what happens with you got the digital, and then you got the smaller businesses that work on paper still.
Okay, so it's clear that the GDPR works on both ways, with paper and digital, and it has that consideration. Okay, so another question: can privacy laws override to national legislation? This is the question, in fact.
Yeah, but basically, and this is when I normally go to legal, because that's where I need help. I don't know how other laws work, but basically, no, privacy laws do not triumph over other laws. They have to work together. So within the GDPR, there are significant provisions, for example, for national security versus privacy, in that we need to, society, we need to have a secure society, in a secure functioning society. And so what it means is that whenever it gets to national security, then it moves into another law, which will be some kind of international law or some kind of local law. And it's the same we have in public interest in the GDPR, to do with protecting our public interests as well. So yeah, there is often a conflict, and I mentioned about the conflict in Sweden of freedom of speech. We have 2 laws in Sweden concerning freedom of speech, and it's because Sweden is a very, very, can we say, they're socialistic in a very strong way, and so it means that freedom of speech is stronger than the data protection, even the GDPR here in Sweden, and we are still battling with that.
Okay, so national laws, for now, they trump over. They win over the data privacy.
Not always. You know, it depends which is the stronger. And you know, this is why GDPR is to do with, you know, I talk about weaving privacy compliance into the fabric of an organization. And this is why it needs to have people like me and people that is not legal guys to be able to make this work. But at the same time, we need to be aware enough to know that what we can do, there's a lot of stuff we can't do, and that's what the legal guys do. And I go and ask for help.
Okay, so there's someone here asking you to repeat the name of your book, Karen, please.
Well, yeah, well, there's the book was hands-on approach to GDPR compliance.
Hands-on approach to GDPR compliance.
Yeah, hands-on approach to GDPR compliance. And it's a little bit difficult to get hold of, actually. It's the IAPP, the International Association of Privacy Professionals, that have published the book. So it's iapp.org.
Okay, so there's another question here. In case of temporary... Sorry? Are you listening to me, Karen? Karen?
Yeah.
Are you there?
I'm listening.
Or am I?
Yeah, I'm here.
So in case of temporary work, of a contract that's temporary, the people that is signing the contract are giving their consent to use the data on the contract. What's the time, the span of time that that consent is valid if the contract is not true? How can I say? Okay, you sign a contract now, you give your consent and your data, but in fact there's something that breaks that contract. So the contract doesn't go on, but you also already gave your consent. So how long can someone keep their consent, if they can keep it at all? Do you understand?
Right. So we need to cover a couple of things here. One is that if you're signing a contract for employment, even if it's temporary employment, the legal basis is not consent, it is contract. Okay? So as long as that contract is enforced, and this is where we get, somebody mentioned to do with when does the laws go stronger than the data protection? There's employment laws. Yeah.
Okay.
So in employment laws, and also there is the rights of the individual. If there is the rights when it comes to if they challenge, you know, even in recruitment, you need to keep why you made a decision not to recruit somebody for a period of time afterwards, in case they challenge you by saying there has been some kind of discrimination. You know, you're a woman, you're a black guy, you're a white guy, or, you know, you're big or small, but if you're discriminated in any way, so even though that you need to, in the GDPR, you need to delete data after a certain time, it could be that the organization needs to keep that data for a period of time in order to protect themselves in case there is some kind of proceedings, legal proceedings afterwards, okay? So that's the recruitment side of this, what you weren't covered with. Then when it comes to actually employment, you've entered into a contract. So the first part, recruiting, when you're doing the recruitment, that is consent, or that is something called legitimate interest. You can use either of those two bases. There's 6 bases. Yeah, I mentioned.
Okay.
6.
Okay. You mentioned.
Yeah. So and so when you're actually recruiting, before you enter into a contract, it could be consent, or it could be something called legitimate interest that you're using. And then that data, it's like in Sweden, it depends on each individual country how it is. But in Sweden, it's normally recommended by HR professionals that, like, CVs and decisions why that person was not recruited is kept for 24 months. And then after that, you can you can delete it to protect the organization. And this actually aligns with GDPR, although GDPR could say, well, you haven't recruited them, delete it. But the employment law, these laws say you can actually keep it for longer. So then you can see how the different laws are working together. Now, if you actually recruit somebody as a temporary contract, they have entered into a contract with you, and still, what is recommended is that you need to look at what the local employment laws are, and you keep that contract and whatever is linked to it as long as is needed to protect your organization in case there are legal proceedings. And that could be 24 months after the contract has finished, but you need to check with your local country.
And there's, just to end this question, is it legal to possess a copy of your documents, your personal documents, of course, to by an organization, if that's legal, if that's all right? You have a physical copy, like a paper with a copy of your. Is that legal?
What do you mean? A copy of your documents?
Yeah, of my documents, of my personal documents.
Yeah, and you give it to someone else?
Yeah, in that it's in following up the question. There's another question by this attendee. That's it. That if it's legal to possess a copy of the documents to identify the person that is writing the contract.
Yeah, as long as it's specific for the purpose, and as long as, you know, you need to set a retention time in your organization on how long you keep documents. So, for example, if it is for the purpose has been an employment contract, whether it's temporary or permanent, and then basically the retention time will be for as long as they are, you know, during the period of employment, and maybe for 2 years after this.
We are approaching the end. We'll have 2 more questions for Karen. And
right, what I'm going to do is I'm just going to move it onto the screen so I can oh, it's funny. I want to be able to
I think that would be fine, just like that, Karen. Don't worry. I think
yeah, but then I can't see you.
Okay.
I mean, that's better. Okay. I'm just going to get it on the screen. Okay. So, can you see it now? I'm just going to...
Yes, perfectly fine. We're seeing your desktop right now.
Yeah. Was it this you wanted to have? Yeah.
It's fine. It's
there we go.
Perfectly fine.
All right. Otherwise, I can't see you in time. There we go. A bit of an improvisation, but that's basically what you find also as a privacy practitioner when you're working in an organization. You need to walk a fine line to make sure you are standing in the shoes of the data subject in your role, even though it can lead to conflicts with other people in the organization. You need to be able to manage this. So it's a lot of compromises and trying to make GDPR work and adapt to how your organization functions.
It is. Yeah, that's why people are asking so many questions now. And there is one here that many organizations see DPOs only as an obligation. What advice would you give to DPOs in order to gain trust and all the other things needed to promote this function that it's becoming so fundamental in organizations today?
Yeah, I would recommend to do our CPP training and join our party of CCPs. We call ourselves privacy owls, and we sort of, what we're trying to do is to sort of bring us together so that we have each other to talk to. And basically it helps us to, we can talk about the issues that we're having, which is often beyond privacy, which is actually dealing with, can we say, maybe not so enthusiastic marketing guys. Maybe marketing is great friends with the CEO, Maybe the CEO doesn't want to listen to you. He prefers to listen to the marketing guys. I know at least, I know 2 DPOs that have resigned due to that, and a third one that got kicked out through to just because of conflict. And that's just in the last year and well, since 25th of May 2018 that I'm aware of personally. And I know that there's many more. So it's a difficult role.
I think you're suggesting to create like a community of DPOs, and that's the way you can make yourself stronger.
Yeah. Well, this is basically what we're doing, actually, because we are a mixture of people doing CPPs. They are 50-50. 50 are legal, 50 are not legal. And we all need each other, and we're starting to reach out to each other and building up our own network, basically. It sort of happened organically. It hasn't really been planned, but we find it easy to talk to each other because we've spent some time together and we have the same kind of values, and we understand how, you know, the dilemmas
Okay, I lost you for.
Are you still there?
Seconds. I am now. So I'm gonna ask you 2 last questions. First of all, if you are rescheduling your employees in an organization, how can GDPR rescheduling about timings of entrance and timings of getting out of the job daily on a daily basis, how can GDPR be a complexity in these terms?
Yeah, well, you have a specific, the timing, I guess. These are employees that, well, the fact is that there is a specific purpose. It could be one of 2 things. One is if they are employees that they are paid, if they go in at 9 o'clock in the morning or 8 o'clock in the morning and they leave, they are paid by the time that they go through the door. Mm-hmm. The other could be because of security. It's in order to, and you know, if you have a fire alarm, you need to know who was in the building and who was out the building if something should go wrong. So, you know, that's personal safety and security. So there are 2 very specific purposes there, but you need to define what the purpose is, and then you have it documented. You know, of the 8 principles, the last one, you need to say, this is why we need to do this. And and that's what you use it for, nothing more than that. Okay. You can't start using the data for something else.
Something other than the purpose, of course. So
yeah, I've come across this. It's been, you know, it's like what I came across once is where they were using this data to check whether people were sneaking out.
Well,
that is only. The thing is that is not legal, because you can check if they are checking out. If the purpose is that they clock in and they clock out, that means they're not sneaking out. So everything is logged, and that is for timekeeping, and that's so they get paid their salary or their monthly salary. But if it's to sort of see, you suspect somebody's sneaking out, you know, you're sort of checking things like that. That is outside of the original purpose. And if you're going to start doing that, then you need to be transparent.
Okay, so I think transparency is the basis here for almost everything about GDPR. So in fact, Karen, and I think we are closing Q&A for now, and I'm glad to say that Karen will come to Portugal in the next 19th to 21st of November. She'll give us, it's the co-organization by IFE, where I'm working, and Privacy, which Karen is the CEO. And we'll have the pleasure to have Karen here in Portugal. So for the 4th edition of the Certified Privacy Practitioner. And I would ask you, Karen, to tell people what are the benefits of this course for someone that is trying to get more knowledge as a DPO, or in fact that's trying to change their career, trying to make a career shift that will put them in that path of a legal being not that legal, as you said before. So what are the benefits of this CPP, of this course?
Yeah, so basically there will be a mixture of, there's normally a mixture of people on the courses. We've had quite a dominance of legal guys turning up for the CPPs in Portugal, and this is one of the motivations why I'm going to be doing this one, to have a non-legal guy delivering this, because outside of Portugal we have actually quite a balance of mixture of legal, non-legal guys, and the fact is that clearly we need to do some legal stuff for the non-legal guys, because you need to get to a level whereby you can speak to the legal guys. And then what we'd spend is a lot of time hands-on and actually saying, okay, we take examples and you need to apply them. You need to problem solve these things. So the legal guys find this really useful because they are forced to actually work with the non-legal guys. And then we actually have to solve problems that are business problems more than legal problems. So from a practical perspective, you walk out of the room feeling that you've actually done something and you've actually learned something, because you haven't just got the facts. You know, it's like we have some competition that's doing similar training. Well, this is where I've actually got the IPPC, IPPE, CIPM, CIPT. I took all of that training a few years ago, but it's a lot of theory that you get fed over several days. And with our training, it is basically you have to do some theory in order to be able to solve the problems, but then you solve the problems, and it's actually rather fun as well. Yeah, so that's basically it. You get hands-on.
Okay, I think that,
and of course you get to spend 3 days with me. So
yes, that's always a pleasure. Indeed. That's also a benefit. That's also a benefit. Well, Karen, it was a pleasure to have this webinar with you. People are still asking questions now. Oh no, it's just someone thanking us both for the webinar. That's also, we thank you for being present. So it was a pleasure to listen to you, to have your inputs. Do you have anything else to say to our attendees, Karen?
I just look forward to see you if you decide to join us in November.
Well, we'll hope so.
Lovely to have an excuse to come to Portugal. It gets pretty cold in Sweden around that time, cold and dark.
Here is cold also, not so cold as Sweden, of course, but also cold, definitely. Well, this webinar will be delivered, because there was a question here if we are sharing the slides of Karen. Not necessarily the slides. We'll share these with you via email, because we'll upload it to YouTube, and then you can see it all again and listen to all the inputs Karen brought us. And well, it was a pleasure, and thanks a lot for being here with us, Karen. I hope to see you in November. And
bye.
I think that's it. Thanks a lot. Thanks a lot. See you next time.